Okay, it's the 8:30 hour, folks. We have a very long calendar today, but we want to make sure everyone gets taken care of. So on 8:30, as I mentioned a moment ago, to those in the courtroom and also remotely, that we're taking pages 6 through 11. Tiquionte Henry versus Affinity Lifestyles, 844-176 first. So the easiest way, because we have a long list of individuals, is I'm going to go through, as I've done in the past, through the listing from the clerk's office on behalf of the plaintiffs. Counsel, would you like to make your appearance, please?
Brianna Switzler, on behalf of plaintiffs, bar number 15653.
And you're on behalf of all plaintiffs, correct?
Correct.
Okay, thank you so very much. On behalf of ArsLV LLC, please. ArsLV LLC, the movement for today. Do we have anyone? None. Okay, we'll figure that one out in just a second. Nevada Beverage, please.
Good morning, Your Honor. Colt, Dodrill, bar 9000, counsel for Nevada Beverage.
Thank you. Costco Wholesale Corporation, please.
Good morning, Your Honor. Marissa Fehrman, 15544, on behalf of defendant Costco Wholesale Corporation.
Thank you. Scientific Instruments, please. Mr. Rasmussen or someone on the firm? Nobody? Does that mean I also have no one for SID US Inc.? Okay, so let's go back. I was making sure. Do we have anybody for Costco Wholesale Corporation SID US Inc.? Mr. Rasmussen, Mr. Flanagan? No, not important out there. Okay, no one. NSF International, please.
Good morning, Your Honor. Jonathan W. Fountain on behalf of NSF International.
Okay, thank you. While this court is not the bill collector, our administration asked us that if we note that there's outstanding fees, at least to mention them. So please do double check. Counsel? Okay. So we go next to Silver Springs Water. No one? Okay. 7-Eleven Inc., please. No one. SFM LLC. No one. KEHE Distributors. Excuse me. Ms. Frister, I thought I saw you on. No? Try again. KEHE Distributors. Anybody?
Your Honor, this is Jim Cavanaugh. I saw Laureen was on and then she got disconnected. I'm not sure what happened.
Okay, we'll circle back. Excuse me. Yeah. WFM Southern Nevada, please. Mr. Brandon, Mr. Spurlock's been on. Anybody? No one. Same thing with United Natural Foods West. Anybody? Milwaukee Instruments.
Rob Robbins for Milwaukee Instruments, bar number 6109.
Thank you. Real Water and Affinity Lifestyles.com. No one?
Mr. Cavanaugh.
Mr. Cavanaugh, are you on for these parties, Real Water and Affinity Lifestyles?
I'm on for Real Water of Tennessee, LLC, Your Honor. I'm not.
Not Real Water Inc.? Okay. The reason why is you're listed as well as, usually it's Mr. O'Dew, but you're listed on this.
That's right.
Okay, so I'm going to put, so did you wish to make an appearance on behalf of Real Water Inc. and InfinityLifestyles.com, or are they not your clients and I should move on?
They're not my client officially today. I'm going to text Mr. O'Dew, find out what's up, though.
Okay, I'll circle back. Okay, ETT1 LLC. No one?
Good morning, Judge Jan Tomasik for ETT1.
Thank you. Okay, that's all the individuals that we show that have attorneys. I need to circle back to a couple of things. KEHE Distributors. Ms. Frister, are you now on?
Yes, Your Honor. Laureen Frister for KEHE Distributors. I was on video and I was kicked off, but I'm still trying to reconnect.
Okay, thanks. You were getting some big static from you as well, so Might want to try and fix that. Okay, so let's circle back again. ArsLV LLC, I've already called you. Is anyone showing up late by chance on ARS?
That was me, Your Honor. I apologize. I
Would you like to make your appearance?
ran in a few minutes. Yes, Dave Blake on behalf of defendant ARS LLC.
We do not have your bar number because it doesn't show you as appearing in this case. Do you want to give your bar number, please?
Yes, 11059.
Okay. Anybody else want to make an appearance who's not yet had a chance to make an appearance on this case? Mr. Cavanaugh, any luck with anybody on behalf of Real Water Inc. and Affinity Lifestyles? Because if not, I'm going to move on to the matter unless there's some reason I should be pausing.
Your Honor, I don't think so. I just texted Mr. O'Du, and because of the nature of the hearing, they weren't involved in this motion.
Okay. Does anyone have any reason I should be waiting? If not, I'm going to move forward. Please speak now. You want me to wait? No? Okay. Then we're going to move forward. What we have today is defendants ArsLV LLC's motion for a more definite statement pursuant to NRCP Rule 12A3E, request for attorney's fees, document 254, plaintiff's opposition thereto, document 279, and did not so reply. So, counsel for movement, go ahead, please. It's your motion.
Sure, Your Honor. I know you've read the papers, and so I don't want to belabor too many of the points, but I did want to highlight a couple of points. The complaint in this matter doesn't allege how much water was purchased, when it was purchased, where it was purchased, even a generic time frame of when the water was purchased. It simply alleges that the product was allegedly defective and it was purchased from ARS LLC, my client. With respect to, we submit that that's not enough to provide a simple and plain statement of the claims against the defendant. And this is really kind of the issue that we ran into is, you know, when you go to prepare an answer, you have to do a due diligence investigation to either admit, deny, or say that you don't know to respond to the allegations. And I think the question here is, if the plaintiff makes an allegation where it's almost impossible for a defendant to either admit or deny, does that satisfy Nevada's notice pleading standard? Essentially, in order for us to do our Rule 11 investigation, plaintiff is asking us to do find a needle in a haystack in terms of doing our due diligence Rule 11 investigation into the facts and the circumstances of the allegations. Search records, who knows when the water was purchased, who knows how much was purchased. And so for those reasons, we felt like a more definite statement would be involved. And as noted in our moving papers, we made an effort to contact Hollow Discovery to see what files had been located there, and Hollow Discovery said they wouldn't give us access. To be clear to the court, I wasn't part of those conversations, and so I don't know exactly what was said. I do know that plaintiff has alleged in their opposition that they weren't even aware of the request, but I do know that Mr. Cook made an inquiry to Hollow Discovery and that they were denied access, and he was denied access. And so I think that's the issue, is if a defendant can't make a good faith Rule 11 inquiry into investigating the nature of the allegations, does that satisfy Nevada's notice pleading standard? We don't think it does. And on that, I'll save any points for rebuttal.
Sure, okay, thank you so much. Counsel in opposition, go ahead, please. Now, just let me make sure before you go forward. This court's not aware of anybody doing any joinders to said motion. We don't see anything on file, but I am appreciative with the fact that there is a number of coordinated, not consolidated cases. Let me just make sure, does anyone feel that they filed a joinder that maybe got filed in the wrong case the court should be addressing? If so, please let me know. Silence, okay. And you didn't receive any joinders, correct?
That's what I ordered.
Then go ahead, please, with your opposition.
Good morning, Your Honor, and I'll try to keep it brief as well. The court in the coordinated matter, we filed numerous complaints over 33 pages long, and we go through excruciating detail in trying to identify the defective manner of the product and the alleged manufacturing defects therein. There's also allegations within the complaint that detail that all of the plaintiffs consumed the water and that by their consumption, they received sort of related liver injuries, specifically to Mr. Henry, who allegedly purchased the water from AV Markets. We say that he had a liver transplant in June of 2021. Specifically, AV Markets alleges that the complaint is so insufficient that they can't render a response. However, by its own motion, it practically concedes it has the information it needs to render some sort of response. They allege that there is a defective product, allegedly defective product, that plaintiffs have pages of information detailing that the complaint alleged that AV Markets purchased this allegedly defective rail water from Costco, and that the plaintiff Tiquionte purchased the allegedly defective product from AV Markets. That in of itself is sufficient, seemingly, especially along with the other 33 pages of the complaint, to render a response. This is a retail store that is in a strict liability action, so they are in the chain of distribution. The most pertinent facts that are relevant to them are that they sold the product, and those are contained in the complaint. Related to the size of the bottle product or the date of purchase, these are all things that can be discovered during discovery, and will likely, as soon as they answer, we'll get those as soon as we can. Also, as mentioned, plaintiffs did not receive the request for additional information that was made to the Holo Depository, the third-party provider. Had counsel reached out to plaintiffs individually, we could have possibly worked something out. And therefore, we would say that the request for fee should be denied on that basis. As we state, Your Honor, the complaint alleges that plaintiff suffered serious personal injuries, that he was hospitalized in June of 2021, that AV Markets purchased from Costco then purchasing the real water from the real water manufacturers themselves, and that plaintiff Henry was rendered ill from his purchased water at AV Markets. We believe that is sufficient and does not need a more definite statement.
Okay. Thank you so very much. Counsel, you get last word. It's your motion. Go ahead, please.
Thank you. Just a couple points that I noted here. Under the current facts, I don't think there's any way that we could respond to the allegations other than deny them based on a lack of information, I believe. We don't know how, which sources the plaintiff purchased all of the real water from. We don't know the quantities, and so are we looking at one bottle of water versus months and months of consuming from other sources? I know that our firm has another real water defendant, and that defendant plaintiff has identified, I believe, one receipt for a single purchase of real water in that case. And so we don't even know if that's the situation here in this case. And I don't think this should be a situation where a party can be brought in based on a highly generic allegation and be forced to engage in discovery. The facts relating to liability should be alleged in the complaint in order to bring this defendant into the action before participating in discovery. And with that, we just request that the court grant the motion for a more definite statement.
Did you want to address your attorney's fee requests? Because that's the second part of your motion.
Yeah,
You're not required to, but you put it in there, so.
No, I think we'll stand on the moving papers on the request for attorney's fees, unless the court has questions.
I do. Do you have, and I understand you were not the person who reached out to Holo, but did anyone reach out to plaintiff?
I don't know for sure.
Counsel is what I meant, not plaintiff, but.
No, I understand that. My guess, I think probably the rational assumption is Mr. Cook would have put it in the motion if he would have reached out to plaintiff. So I don't think, I'm not aware that he did. I'm not aware of any facts like that. Okay,
I appreciate it. Thanks very much. Okay, there being no other joinders, any other matters, the court's going to make its ruling. The court's ruling on defendant ArsLV LLC's motion for a more definite statement pursuant to NRCP 12A3E and request for attorney's fees, document 254, is denied without prejudice. The court's reasoning is as such. I'm going to address the attorney's fees first. Realistically, with regards to requests for attorney's fees, I don't see a standard under the NRCP. I don't see a standard under the EDCR with not even reaching with. I appreciate your veracity in saying, whether you reached out to plaintiff's counsel so they didn't weren't reached out to. I don't have any firsthand knowledge of what really was the scope, but if a third-party provider doesn't do something to seek attorney's fees against plaintiff's counsel when they weren't even reached out to, really the court doesn't see that there's a basis on any of the various bases set forth in the motion, so therefore that would be denied under applicable case law. With regards to the motion for a more definite statement under 12A3E, the court also finds that that should be denied. Realistically, Nevada's Nevada, it's not the federal standard, right? So you have to look at standard 8A, right? It's required to contain a short and plain statement of the claim showing the pleader is entitled to relief. It's not required to provide all the additional details that are sought realistically in this motion. And you can look at the Buzz-Stew analysis, you also look at Hall versus SSF, the Hall citation 112 Nevada 1384, it's cited in the briefs. And when you look at the amended complaint, because remember that's the operative document the court needs to look at. And it's referenced in the opposition in paragraphs 1, 2, 3, 46, 65 to 70, 74, 101 to 107, 108 to 120, 121 to 224. There is, in that 33-page-ish complaint, there is a lot of facts and information now, realizing that it doesn't only relate to your client, but it does meet the standard of Rule 8. It gives enough information about it was purchased, who it was purchased from, who purchased it, what ended up happening, and what's the nature of the essence of the claims. And under Buzz-Stew and its progeny, the court finds that that is appropriate, and would therefore, like it stated a moment ago, needs to deny without prejudice the motion under 12A3E. It is so ordered. That means counsel for the non-movement. Plaintiff's counsel means that you get to prepare the order, plead pursuant to EDCR 7.21. That means it goes to the DC 31 inbox within said 14 days. Is there any reason that you think you need more than the 14 days?
I think that should be sufficient.
Okay, so DC 31 inbox in accordance with the administrative order, please do make sure you circulate it to movements counsel. Question for counsels who are on. Normally we would ask that it gets circulated to everyone, even if you're not potentially in movement. Do people actually want it circulated to you, this proposed order? So it's just to be emailed globally to everyone? Or is anybody wanting to state that they waive circulation on the record today? If you want to waive it, let us know. If not, I'm going to ask counsel for plaintiff to circulate it to everybody.
I waive it on behalf of Rural Water, Tennessee, Your Honor.
Okay, so you have Mr. Cavanaugh. I know it was you speaking, but remember with all the individuals that we have, we just need people to identify them each time they speak, please.
Thank you. Jim Cavanaugh, and I waive.
Rob Robbins from Milwaukee, I waive.
Colt Dodrill for Nevada Beverage, we also waive.
Jonathan Fountain for NSF International, we waive.
Okay, last counsel, wait, hold a second, last counsel, you kind of cut in and out. I heard the international, do you mind just repeating your line again, please?
NSF International, Your Honor.
Thank you. Did you say you waived, counsel?
Yes, Your Honor.
Okay, thanks. Ms. Frister, were you about to speak?
Yes, Your Honor. Laureen Frister for KV Distributors, and we waive as well.
Okay.
Marissa Fehrman for Costco, we also waive.
Jan Tomasik for ETT1, we waive.
Okay. Anybody else wish to be heard? If not, so counsel, you heard who waived, whether you wish to still circulate it to everyone and then see if they wish to respond, but please make a note of that when you do submit it to the court that there's either waivers and open court that was circulated, okay? Do appreciate anything else we can do for you for pages 6 through 11? If not, we're moving on. Anything else for moving? Okay. I appreciate anybody else who's remotely. Anybody need anything? No? Okay. If anyone's here for our 10. Thank you so very much. If anyone's here for the 10:30, we've got a lot of matters in the in-between time, so just make sure you pop your name in the chat before we get to that one. Thank you so very much. Have a good one. We're moving on. We are now going.
Thank you, Your Honor.
Thank you so much.